If ban is approved by the court, 6-week trigger ban will come into force. Florida's Supreme Court heard on Friday morning debate over legal appeal to lift state's 15-week abortion ban for alleged violations of state's constitution. The trial was part an ongoing lawsuit against state of Florida by the American Civil Liberties Union on behalf Planned Parenthood, Center for Reproductive Rights, and other abortion providers. In July 2022, a lower state court ruled that the ban violated the state constitution and was temporarily suspended. After state objected to judge's decision, law came into force again on same day. The state Supreme Court took up the case in January at the plaintiff's request. The plaintiff's attorney, Whitney White, was the first to speak before the Supreme Court. The judges interrupted opening speech several times with questions about the case and whether state constitution's privacy protections include abortion rights. The judges asked White why privacy provision passed through a voter referendum in 1980s did not spark controversy between anti-abortion and pro-abortion groups at time. This suggested that a right to abortion was not implied in privacy clause. This is a 50-year-old reflection by our society and our state that elected representatives of the people believe there is a compelling interest in preserving human life. Why should we, as the court, succumb to this? Asked Chief Justice Carlos Muniz White. White argued that Florida's privacy clause provides broader privacy protections than the U.S. Constitution. Attorney present for state, Henry Whittaker, began his keynote by arguing that the Florida Constitution did not protect abortion rights, then was interrupted by questions from judges. Muniz asked Whitaker how state believes that voters who approve the privacy amendment in Constitution should have judges determine what they consider intruding on their privacy. Whitaker also noted that Floridians had voted in Roe v. in the 1980s. He argued that they had not internalized the Wade case. Roe v. Wade might be a nasty situation. It might be semantically absurd to talk about it in terms of privacy. But for better or worse, it was part of our cultural lexicon, Muniz said. Republican presidential candidate Florida Governor Ron DeSantis in Lexington, SC, on June 2, 2023. Artie Walker Jr.AP speaks at a campaign event. Judge Jamie Grosshans asked Whittaker how state would deal with 30-year precedent-setting consequences if court upheld ban. If we as a court take your legal approach to this change, it will affect dozens other cases outside the context of abortion and dozens other issues related to greater decision-making autonomy, Grosshans said. Whittaker responded, I think the concern is much less than it appears, Your Honor. When White responded to Whittaker's claims that secrecy clause only meant protecting information from government surveillance, he said the court had repeatedly applied secrecy clause outside of